about a few weeks back, but still we still need more clarity, or maybe we need more discussion on this. So we thought we will bring in more discussions into this subject. So I have so Mr. Radhakrishna Garu, who is the president of FDPPI Hyderabad. So he'll be addressing the audience, and then we'll get into the discussions with the speakers.
Thank you, Praveen, and hi all. So good afternoon, sir, Naavi sir, Dr. Anirban Ghosh, Praveen, Vijayashankar Na, and all. Regarding FDPPA, we will discuss in detail a little later. But briefly, I would like to introduce FDPPA, Foundation of Data Protection Professionals in India, is a pioneer organization, is a non-profit organization that was established in 2019, especially to promote the data protection in India. Its mission basically is to empower the community of data protection professionals in India with the necessary knowledge and enhanced skill set for the data protection professionals. And its activities mainly include training, certifications, and organizing conferences, workshops, researches, and it has many publications, collaborations also it will organize. In one word, if I am asked to say, FDPPA is a valuable resource for anyone who is interested in data protection in India. We'll discuss in detail a little later. But before going into the session, I would say that 11th August of this year should be marked by all of us. On that day, Digital Personal Data Protection Act 2003 was given assent to by the President. I doubt if there is any other legislation in India which brought in with it so many challenges, enormous number of challenges, and equally enormous quantum of opportunities with it. And almost for the last 1 decade, it is being discussed in the corporates, in the legislative circles. Now the act has become a reality. So FDPP Hyderabad intended to conduct a session for the benefit of the data protection professionals and all the people who are interested in DPDPA. Yes, this session is going to deep dive into the act and its nitty-gritties. We have the two of the best brains in India and for working in this data protection laws, Dr. Naavi sir and Dr. Anirban Ghosh, who will discuss in detail about the act and the opportunities available for data protection professionals. And this event is being broadcast on YouTube channel also. No issue if the participants are not able to enter into this session, they will be diverted to that. And of course, some of the participants asked me whether certificates will be, CP certificates will be issued. As already informed in the groups, the ISACA Hyderabad members will be given CP certificates by ISACA chapter. Others who require any certificate, we will issue participation certificates, definitely. So for that purpose, we are sharing 2 Google Forms towards the end of the session, one by ISACA, another for other members, for the benefit of other members. You give the details and we will issue certificates, participation certificates through email. And we'll have the Q&A at the end. In between, if anybody have any questions, I request them to share them in the chat box instead of breaking the chain of proceedings. Now, so without spending much more time, let us go directly into the session. So our first session will be taken by Dr. Naavi, sir, is Mr. I think there is nobody in the field who is not familiar cyber law or cyber forensics and this data protection laws. The people who are dealing in these subjects, I think everybody knows him. There is nobody is not familiar with Naavi, sir. His actual name is Vijayashankar Na. He's most popular known as Naavi. In fact, so he's one of the best data governance and data protection consultants in India. He has his own corporate called Ujjwala Consultants Private Limited, and he has started Foundation of Data Protection Professionals in India. He is the honorary executive chairman for that. So he's pioneer. Actually, originally he's pioneer in the field of cyber laws. He's working on them for the last about 4 decades. He has written many books. I think he has written the first book on IT law, first physical book as well as the e-book also. He has also written other books like Cyber Laws for Engineers, and his book on Data Protection Act of India, even before the act was passed, he has written the book is a wonderful book. He has written in a very lucid language, anybody can understand. I think not only data protection professionals, everybody should read that book. And as far as I remember, in a small book on Section 65B of the Evidence Act, that is the only book in India written on Section 65B. And he has many portals like Naavi.org, and he is also a pioneer in websites such as Cyber Evidence Archival. He has a website for that, ceac.in. And most of the people remember he was dealing with many important cases in India. One such case is ICICI Bank, the Shankar versus ICICI Bank. In that case, he has throughout the session, starting from the first education to the tribunal and Madras High Court level, he has dealt that case. In that, he was successful. In fact, very famous case. And bank was asked to pay compensation to the petitioner. If I remember it, the compensation of 12.85 lakh was paid to the petitioner. So, like that, there are many things to discuss about Naavi, sir. Please visit these portals, Naavi.org, cyberlawcollege.org, FDPPA.in. You will have enormous amount of knowledge in that. So with this, I request Naavi, sir, to take the session on DPDPA, Digital Personal Data Protection Act 2023. Please, sir.
Thank you, Radhakrishna. And thanks to ISACA Hyderabad and all the members who are present here. FDPPI is very happy to interact with you. And in fact, this is the program which Radhakrishna has launched as the first program of the FDPPI chapter in Hyderabad. So I congratulate him for the initiatives which he has taken. It was indeed a long wait for most of us for this particular law. In fact, the first time the law was actually presented in the parliament perhaps was in 2006 when the Information Technology Act was also sought to be amended. So along with ITAA 2006, this Personal Data Protection Act of 2006 had been presented as a bill in the parliament. However, that did not get passed, and only after 2017 with the what we call as Puttaswamy judgment, the Supreme Court spoke about the privacy being a fundamental right in India, that more action started in this domain, and we now have this DPDPA 2023. FDPPI recently had the privilege of meeting Justice K.S. Puttaswamy, who was the person responsible for this act to come in India. That gentleman, of course, is today 98 years old. We actually awarded him a title from FDPPI's side as Privacy Pitamaha. And we are thankful that the government has ultimately come up with this law, which was something which professionals waited for a long time. There are different kinds of professionals who are looking at this act. One was, of course, the privacy activists who wanted privacy to be recognized as an important human right and wanted appropriate, you can say, restrictions on the use of personal data, particularly by the business and the government. And the industry was, of course, looking at it as with some kind of a fear that if the law is very stringent, their business could be affected. And professionals were also looking at it because we know that in corporate environment, we all handle data, and we would like to know whether there is any reason to watch our backs with penalties which this law or this kind of law could apply. Since 2018, after GDPR became an effective law, we have all been worried about companies being penalized with large penalties. Fortunately, of course, India basically is a data processor in most of the GDPR instances, and we have not had any instances of GDPR fines. But globally, we know that the GDPR fines have gone to the astronomical levels of up to $1.2 billion US. And the industry was very fearful that India also we may come to a situation where penalties are running to crores of rupees based on a percentage of turnover could be imposed. In fact, GDPR has a maximum penalty of 4% on the turnover. And in fact, Singapore, of course, GDPR was 4% of the global turnover, and Singapore went to the extent of making the penalty up to 10% of the Singapore turnover. So definitely, this was something which was being watched out. And fortunately, I think the government decided that we have to take different stakeholders together, both the business, government, and the privacy activists, and came up with this law, DPDPA, which is as reasonably industry friendly as it could be. Privacy activists will continue to oppose, saying that no, this is a very diluted law. But ultimately, we have to see that industries need to exist. We cannot, for the sake of the privacy right, kill an industry. So we have to ensure that there is a harmonization of the requirements between the industry and the privacy activists. And to some extent, that has been achieved in this particular act. We will, as we go ahead with this particular session, briefly talk about the contents of this act, and then we will go into a lot of discussions. As Radhakrishna was telling, that there have been a wide industry-wide discussions on this act since the last 1 month, which is actually something which people like us are very happy, because in 2000, when the Information Technology Act came, the industry had not actually recognized the emergence of the law at all for a long time. In fact, for several years, when ITA 2000 became a law, we used to see that even at the government level, the earlier draft law called E-Commerce Act 1998 was considered as the law of the land. In fact, if you go through Naavi.org and open up the historical pages, which started right from 1998, 99 onwards, you will see that at many places I would have perhaps pointed out how our US consulate had been talking about E-Commerce Act 1998 when it was not there at all. And the industry level, very little awareness had been there, and it took years after years to actually make companies realize that there is an act called Information Technology Act. Even today, people have recognized DPDPA, but they have forgotten that there is a law called Information Technology Act. And in fact, as we go forward, there is only one section of Information Technology Act which has been replaced with this DPDPA, which means that the rest of it, IT Act remains, and IT Act, that is Information Technology Act, applies to data in general, which includes personal data as well as non-personal data. And this DPDPA covers personal data. So together, they are important for the organizations, and several aspects of personal data protection also fall within the range of ITA 2000. In fact, if a data principal has to claim compensation for any data related loss, the law which he has to invoke is Information Technology Act and the adjudication under Section 43 of the Information Technology Act. That is the close interaction between ITA 2000 and DPDPA. If there is a dispute between data fiduciary and data processor, where a data breach has taken place with the data processor, then data fiduciary has to claim damages from data processor. Again, he has to invoke Information Technology Act for that purpose. So Information Technology Act and DPDPA will work together, and that is the reason why FDPPI in its training programs now, which we call as the module on Indian law, has integrated the Information Technology Act and DPDPA into one single training program. So similarly, when we speak of the audit under this particular act for data auditors and data protection officers, we have integrated the requirements of compliance of this act along with the requirements of protection of personal data under ITA 2000, as also the BIS standard for data governance. So we have an integrated model of data protection audit, which of course on some other day, some other occasion, perhaps we'll have time to discuss. So this is the background with which now we are looking at DPDPA as the future of data protection regulations in India. Just a bird's eye view of this particular act, we need to look at what is DPDPA and its applicability. Then we briefly can look at obligations and penalties and what kind of measures of compliance the industry has to look at. Rest of it, we will always take it up in questions and answers. So this DPDPA, which is Digital Personal Data Protection Act, by name itself brings the focus on the handling or governing the digital personal data. So we don't just fancy and say we are protecting the privacy, because the concept of privacy is very complex. And we say privacy is a state of mind of a person to feel left alone. Okay, a person feeling left alone, if I have to understand as an organization and then protect that privacy, it is practically not possible. And to have a law, to make a law which protects the feeling of being left alone and about 140 crores of people, again, it is an impossibility. So it is only theoretical that people have been talking of, can we pass a law for protecting privacy? So what the government has done is, while privacy protection is the fundamental objective of this law, what we are indicating in the statutory law is how digital personal data has to be governed. Now, which means that we are looking at personal data in digital form, which is either collected and processed by a computer, or we have collected it manually and then made it into a digital document. So this law applies to that kind of data. The question therefore arises, what about privacy in non-digital form? The government is not saying that there is no privacy if it is in paper form. What it only says is this act will look at digital personal data. If there is an issue in terms of protection of privacy in non-digital format, the current clause has to take care of it. the Constitution has recognized that under Article 21, privacy is a right. So whether it is orally or through paper or through electronic means, the constitutional right remains. Now, whoever is responsible for the constitutional right has to take care of that responsibility. And in the early days, jurisprudence people were telling that a constitutional right is an obligation for the government and not necessarily an obligation for the private sector. But Kerala High Court in the Umanchandi case made a different observation. It said that the constitutional obligations cannot be ignored even by the private sector. So it should be considered as an obligation by the private sector also. So therefore, I see that the portion of privacy which has been omitted by this law is adequately covered elsewhere. And the government feels that if you look at the risk profile, risk of privacy loss in digital world is far, far more than the risk of loss in the paper world or even oral world, and existing laws of IPC should be able to take care of that. So with this particular law focuses on digital personal data, which is a matter of prime, you can say, focus at this point of time. And it imposes certain obligations on the corporate entities, and penalties could be up to 250 crores or higher. There are no criminal punishments in this particular act. However, when you combine it with ITA 2000, criminal punishments could come forth, because whenever a data breach happens in personal data, it is also a breach in ITA 2000. And therefore, if there is a wrongful act under ITA 2000, which has caused the data breach recognized under DPDPA, punishments will come under Information Technology Act, because ITA 2000 has a section called Section 66, according to which any diminishing of the value of information residing inside the computer can be considered as an offense with 3 years imprisonment. Impersonation, identity theft, which are all privacy related issues, are covered under Information Technology Act. So this act doesn't have criminal punishments, but it is covered under Information Technology Act. As I told you, it replaces Section 43 capital A of ITA 2000. However, there are several other sections of ITA 2000, such as Section 72A, 67C, then 70B, 69 family, 79, 85, they all remain, and they address different aspects of privacy and consequences of privacy being breached. Therefore, we are saying that ITA 2000 and this is a twin set of laws which will be affecting our data protection requirements in the coming days. Now, if that is the law, and we are looking at a corporate entity, the very first corporate step I look at in terms of what this company suggests is for us to decide whether this law is applicable to us or not. So that is why I am suggesting that all companies need to take this very first corporate step, which is the board meeting together and passing a resolution, taking recognition of this act first. Okay, the members of the board have to recognize that there is a law like this, and we need to actually make a business impact assessment. And who will do that business impact assessment? Maybe they will call the CFO and say that what is the financial risk as a consequence of this act having been passed. I mean, trying to have a cyber insurance of 250 crores or anything more. So that is the first thing. Of course, CFO may not know much about the act itself. So he will immediately call the CISO or somebody and say that, please let me know what is this act. Okay, so that is how I think the first corporate step has to be rolled out. And I hope most of the companies by this time in the last 1 month must have had a board meeting, and they should have taken some action on this. With this background, if we try to explore the requirements, of whether DPDPA will apply to us, the Act appears to be applicable to all type of entities, unless it is exempted specifically by a notification, which means that whether it is a small scale industry or a large scale industry, whether it's an IT company, non-IT company, whether it's an educational institution, or whether it is a society like ISACA or FDPPI, as of now, there is no exemption and all of us are coming under the DPDPA. Maybe in future, government may think of creating a category of exempted data fiduciaries. We will have to wait and see. But if any person or any organization is processing personal data in India, then such an organization comes under this Act. In case data is being processed outside India, if that data is related to any goods or services which are being provided to data principals in India, that is directly to the individuals, then even if the data is being processed outside India, that comes under this Act. If any individual is processing any personal data, if it is for business purpose, that will also come under this particular Act. But if he is processing it for personal domestic reasons, it may not come under this Act. The thing which comes under this Act is what we call as personal data. Personal data is data related to an individual, and if a set of data identifies an individual, we call that as a personal data. Data which is related to a company, even a HUF, even a proprietary firm, or even a LLP or something like that, is not personal data. That is business data. So we have to make a distinction of personal business data and personal data to understand the applicability of this particular law. Every organization has got employees, therefore employee data comes under this Act, but there is a provision for legitimate use, and with that, employee data may be processed without much of a difficulty. Okay, and if an organization is handling any retail customers, then that will come under this Act. So even manufacturing companies which are having, say, retail showrooms, or they are selling their products through e-commerce websites, they also come under DPDPA. Okay, so personal data processed by a business entity could be considered as business contact information. It should be exempt. More clarity on this, of course, may come sometime later. Otherwise, personal data is data about an individual, which is something which can identify an individual. See, in our, let us say, corporate environment, we sometimes have elements of personal data. We call that as data identifiers, and GDPR kind of law blindly considers everything as personal data. For example, a cookie on a website is considered personal data in GDPR. Now, I personally feel that only if the data is able to identify an individual, then it should be called as personal data. Otherwise, it is an identifier, but not personal data. Maybe it is necessary for the industry to recognize a category of data called personal identifiers not amounting to personal data. Like in the Income Tax Act, we have got a category of non-residents and residents but not residents kind of a thing. But this concept has not yet crystallized, and hopefully it will come in due course, because we are saying something which is not there in GDPR. The industry will frown if I say something against GDPR, because people think GDPR is the gold standard of privacy. But GDPR is to be commended for the what it did for privacy across the globe, but that doesn't mean that we cannot have a law which is better than GDPR. So the one thing which we want professionals to realize is to consider DPDPA as an independent sovereign law, and we have to look at it as something which can have its own interpretations, And it is not necessary that we toe the line of GDPR in all aspects. Okay. So in an organization, what happens? We have got these personal identifiers lying around in different places. And sometimes when like a jigsaw puzzle, two of these identifiers come together, they together become an identifiable personal data. So personal data gets generated in the ordinary course of business, and that is where the identity of personal data, discovery of personal data becomes a very difficult task. So when we want to apply this data, we need to actually create an inventory of personal data, and we have to have our own system of putting together identifiers and then creating a table of personal data set with appropriate identity and so on. So this is another important preparatory task which is necessary for taking on this particular act. Then the next question which an organization has to look at is, who am I as far as this DPDP is concerned? Am I a data fiduciary? Am I called a data processor? Am I the data principal if I am an individual? Am I a significant data fiduciary? Am I somebody called a consent manager? So these are all the different roles which this particular act has given, and depending upon the activity of an organization, it may have different roles, and sometimes the same organization may be a data fiduciary in one process, it may be a data processor in another process. Therefore, while trying to build an inventory of data, we need to actually first start with an inventory of processes, and within each process we have to identify, am I a data fiduciary, am I a joint data fiduciary, or am I a data processor? This becomes very important for us to determine what compliance is there. Government has said that they will separately come up with some kind of a guideline on identifying what is called significant data fiduciary. See, various other laws spoke about data being sensitive. So there was personal data and sensitive personal data. India also had sensitive personal data concept under section 43 capital A. And that's why the rule of reasonable security practice was called FDPPI rules. So today, most of the companies understand FDPPI rules, but now there is no FDPPI rules. Why? Because the categorization called significant, the data which is considered as either a special category of data or a sensitive personal data is no longer there. Instead, this particular act directly categorizes data fiduciaries into general data fiduciaries and significant data fiduciaries. And while defining a significant data fiduciary, it will follow multiple criteria like the volume of personal data processed, sensitivity of personal data processed. Therefore, the sensitive personal data comes here in the form of identifying a significant data fiduciary. So therefore, even if an organization is small, even if the number of employees is small, and the number of data sets which is processed is being small, if the data is very sensitive, then government can pinpoint that particular industry or a class of such industries and say this class of data fiduciaries will be called sensitive, significant data fiduciaries. So it will take into account the risk to the rights of the data principal, potential impact on the sovereignty and integrity of India, risk to electoral democracy, security of the state, and public order. On any of these criteria, the government may define either a single data fiduciary or a class of data fiduciaries as significant data fiduciaries. This way, the government retains the option to choose a particular class and then apply this category. And once a significant data fiduciary is defined, then there may be some special obligations related to them. We'll see what special obligations a little later on. And another important first step which an organization has to look at is what to do with legacy data. See, many laws just gave a new law without worrying about what happens to the legacy data. So here our act has clearly mentioned that if you already have personal data, then you must try to get a consent under the new act. This new consent may have something different from the previous this thing. So even if you are processing personal data based on a consent so far, it is necessary for you to send out a communication to all the current set of data principals to ask for a new consent. Now, when you ask for a new consent, you have to send, let us say, an email. This email may actually bounce back also because you may not have a correct email address, which means that the persons whose data you are processing, you have a wrong email address. So the first thing is to eliminate such data principals because you have no right to continue processing that particular data. Second, some of these people may reply back to you saying that I don't want you to continue processing. Now, once you receive that, that also has to be eliminated. However, if people reply positively, or as it may generally happen, they just keep quiet and don't send you any reply, then if you can show me an audit record saying that you have delivered a request for consent, then all those persons' personal data you can continue to process without an issue. But who knows that after 1 week you have started processing, after another 15 days you may get a notice from the same person saying that last month you sent me a request, I was too busy, could not reply. Now I am saying please don't process, which means that you have to send the request for renewal of notice to all your current data principals, then monitor if any of them bounces back, any of them send you a rejection immediately or anytime, and then accordingly prune your list of data principals whom you have to process. So this is another major activity which you need to work on. But if you don't get the response, at least you can continue. And such a notice has to be given in at least 22 languages, which is as per Schedule 8. You have to give it in English with an option for the person to get the same notice in 22 languages. Fortunately, the type of notice is very simple. Earlier, we had a very complicated notice with several points to be covered there. Here, you have to only tell the data principal what is the type personal data which is being collected and why, the purpose. Other than this, you have to only tell him that if you have any grievance, we have a grievance redressal mechanism. If you have got any complaint, this is the Data Protection Board email address. You can send the complaint there. So now notice is very simple. So even if you are thinking of translating it to multiple languages, it should not be a problem. But remember that like in every other law, the onus of proof to show that you have got the consent remains with the company. And therefore, you should get the consent and tag it with the personal data. The significant data fiduciaries have three main obligations. One is to appoint a data protection officer who is based in India and who should be senior enough to be considered as responsible directly to the board. And he will also be the point of contact for grievance redressal. Okay, so he is a data principle oriented person, and he should be capable of dealing with persons who may be very unreasonable and they may raise complaints and irritate the data protection officer. So to be a data protection officer, it is very tough. Now you should have that kind of a soft, empathetic approach to deal with the people. Like people say, people like us who are in banks, we know that in the bank, a old depositor is always a pain for most of the people because dealing with them is very tough. But that is what is required for a good DPO. You cannot live in an ivory tower and say, I am the best IT person in India and why should I care? You don't understand what is there in IT. People will say that, people will come up with all sorts of complaints. Some of them are very ridiculous, but you cannot put them down. Rather, you should be able to meet their grievances and redress them. So being a data protection officer is a combination of being the best technical mind, the legal mind, and also being able to handle this PR with the data principles. Then the second aspect of a significant data fiduciary is to appoint an independent data auditor who will evaluate the compliance in accordance with the provisions of the Act. Probably he will be an external auditor. Once in a year, he will do this audit. Third is undertaking periodic, what we call as a data protection impact assessment, so that from time to time, you will analyze whether we are in compliance or not. Earlier, the word concurrent audit was used. Now it has not been used, but still I think the concept is similar. Other than these special obligations of the significant data fiduciaries, the general obligations applicable to all data fiduciaries is one, to be compliant with the law in general, have a valid contract if you are outsourcing any data processing, personal data processing. Okay, if it is non-personal data processing, it goes into the Information Technology Act, but personal data processing comes here. And if the data is collected at one point of time, but subsequently used for decision making or disclosure, it has to be updated from time to time. Then you have to implement appropriate technical and organizational measures, which is what we generally call as compliance by design, and then take reasonable safeguards to protect the data, which is the CIA, confidentiality, integrity, and availability of personal data in the organization. And in case, unfortunately, there is any data breach, notify the data breach both to the Data Protection Board and to the data principal within a reasonable time. The time limit will be perhaps given in the subsequent notification. You know, in ITA 2000, within 6 hours, you have to give the data breach notification. So if a data breach happens and it is of even personal data, at least the CERT-in will be waiting for your notification within 6 hours. So here, even if 72 hours something is given, as was in the previous versions, you still have to be ready to report to the CERT-in at a much quicker time frame. Now, other obligations, one has to process it for lawful purpose with consent or for specified legitimate users. Give a notice and take a consent, have a grievance redressal system, give the business contact information of the data protection officer, and where data protection officer is not required, like the non-significant data fiduciaries, at least a compliance officer's details have to be given. And sometimes if a person asks you to withdraw the consent and erase the data, if there is no other compulsions of law, it is an obligation for you to erase. If you have got other obligations, don't delete it. In fact, ITA 2000 has many cases where you have to maintain data for at least 6 months, in some cases for 5 years. And IT Act, that is the Income Tax Act, and others may require your data to be kept for a longer time. So only after taking that into consideration, you have an obligation to erase the data once the purpose for which it was collected is over. And in the case of people with language preferences, you have to give it to them. And there is also a provision called consent manager. Maybe Anirban can speak more about consent manager. At that time, I will perhaps expand on that. And as I told you, withdrawal of consent, when it is there, if it adversely affects the organization, that is data fiduciary, you can ask for some compensation from the data principal. Like in the case of right to information, if you ask for right to information and if it requires printing of voluminous data, the information officer can ask you to pay the cost of the printing. Likewise here also, when the withdrawal of consent takes place, if there is any cost incidence, data fiduciary may say that you have to take care of that particular cost. Then as far as publicly available data is concerned, this act has a very unique feature. It says, if personal data has been made publicly available by a data principal, then such data can be processed and it will not actually come under this act. So it becomes like an anonymized data. you can process it. But you have to ensure that the data is being made publicly available by the individual. If somebody has stolen my data and put it in the public place, that does not constitute public data. Children's data, obviously you should have the consent from the guardians. Whatever is applicable to children is also applicable to other people who are not capable of taking their own decisions, like mentally challenged persons and so on. Now, there are certain cases where legitimate users have been defined, and in such cases, explicit consent is not required. It is not that only government has taken such things. Private sector, in many of its activities, can use data under legitimate use. For example, when a data principal has voluntarily provided the information, or when there is a legal obligation to comply with judgments for medical emergency, and for taking any action during a disaster, flood, or something like that. And even in the case of employment, if you want to process the personal data for the purpose of employment, it is considered as a legitimate use. And also to protect the employer from, say, frauds, corporate espionage, and other things, you can process employees' data. This is another area where this act differs from GDPR. GDPR is restricting the use of employee data very significantly. Here, it is much more industry friendly. As far as the rights are concerned, this act talks of rights along with the duties. It expects that there are 4 kinds of rights. One is the right to access, where a person can ask a company, are you processing my data? If so, tell me what you are doing. Give me a summary kind of a thing. Second is right to correction and erasure, that the data principal can ask the company to correct the data and say that if the purpose is over, please erase it. That erasure happens if the company does not have any other legal compulsion to retain it. Then third right is right of grievance redressal. And fourth right is right to nominate the personal data to my legal heirs, perhaps, or any other person who is accountable for the legal error. This is going to be another very important area in terms of compliance, because excepting the bankers and such people who handle the property, the IT companies are not fully aware of how to deal with the deceased data. Now they have to have policies for that, and that is something which will be necessary to work on a separate plane. Like you should have claim procedure for personal data, because personal data may be very valuable. It may have IP rights. It may have, say, NFT or Bitcoin data, which may be just there in your email address. So they are very valuable, and it has got a property value, and therefore right to nomination has to be handled very, very responsibly. You cannot simply give away the password to somebody who claims that he is the nominee, because who is the nominee, his identity, etc., will also have to be looked at. This is another new area for industries to explore. Then as far as the duties are concerned, data principals are expected to, first of all, be law-abiding citizens. They have to comply with all applicable laws. If there is a Rohingyas who is in India without any permission, he cannot say that I have got privacy rights. So this law is very clear that this law provides certain rights, and rights are applicable to only responsible citizens who are law-abiding persons. It can be non-citizens also, but there should be law-abiding persons. Then they should not impersonate. They should not suppress any material information. They should not register a false or frivolous grievance. They should be able to furnish information which is verifiably authentic. These are the duties of data principals, which is very important and very innovative. Nowhere else in the world that is being thought of. And in fact, in penalties, if somebody doesn't follow these duties, up to 10,000 rupees, there can be a penalty imposed on the data principal, like the courts which normally impose costs on frivolous public interest litigations. Now, cross-border transfer, at this point of time, the Act does not say any restrictions. We have to wait and see if in future certain countries are notified as blacklisted countries. At this point of time, there is no cross-border restrictions. Penalties are classified into 7 different categories. Maximum penalty under this table is 250 crores, but penalty under one category can be combined with another category, so the total penalty can be higher than 250 crores. There is also a viewpoint which some people have expressed that if there are data breaches of 100 data principals, maybe this penalty could be multiplied by that 100. We do not know how the Data Protection Board will say interpret that, but anyway, the penalty can be huge, and it is not restricted to 250 crores, not even restricted to 500 crores. Penalties may be invoked by a data principal when he makes a complaint and the Data Protection Board conducts an inquiry, and during the inquiry, if it finds that there is a non-compliance, this penalty can be imposed. When penalty is imposed, the penalty is collected and credited to the Consolidated Fund of India. This 200 crores, 250 crores is not coming to the data principal, because this law is meant to discipline the data fiduciary industry. So therefore, there is a provision that you have to be compliant for the following points. If not, you will be required to pay penalties, and that penalty goes for to the Consolidated Fund of India. If individuals want to get any compensation, probably the Data Protection Board can direct the data fiduciary to pay some compensation. Otherwise, the data principal has to approach the adjudicator under Information Technology Act and then claim the compensation. Now, if Data Protection Board comes to know of an incident outside a complaint, then also they can order an inquiry. And if Data Protection Board wants to conduct an inquiry, it will give opportunity for the data fiduciary to present its case, and then gives out this award. It's not an award, it's a penalty. And if people are not happy with that, they can go for an appeal to TDSAT. And if the decision of TDSAT is not acceptable, they can go to Supreme Court, which means that there is no other civil court. Lawyers may please take note that there is not going to be any case in any civil court as far as data protection law is concerned. It is Data Protection Board, TDSAT, and then Supreme Court. In the ITA 2000, there was a 5 crore limit for adjudication, and above 5 crore it could go to the court. And then after TDSAT as an appeal authority under ITA 2000, the appeal was coming back to High Court and then only going to Supreme Court. Here, this exclusive jurisdiction of the DPB bars any other civil court, irrespective of the amount involved, to take up this violation of Data Protection Act. I have already covered these rights of the data principal. So if you think this is what the Act is in brief, then companies need to start working on the compliance by creating an inventory of personal data, segregating the what I call as a DPDPA data from GDPR data, because you cannot apply GDPR on Indian data or Indian law on GDPR data. So you need to have a segregation of data, however difficult is that is for your technology group, you have to get it done. So segregate DPDPA data from GDPR data or CCPA data or Singapore data, estimate the non-employee personal data exposure. That is, employees will be there everywhere. Non-employee personal data depends on the type of activity you are in. Please make an estimate and include it in the inventory. Send consent requests and follow up on these bounced messages, rejection, and keep evidence of the messages sent. Set up policy for rights management, like how do you handle data access and erasure requests, check on nomination requirements, set up a deceased data principal policy and claim settlement policy, develop a legitimate use policy, revise the notice formats if you are using anything, and consent recording process, develop a data retention policy in compliance with this particular law, develop a grievance redressal policy and a setup, identify processes which involve personal data, because you can have different roles in different processes I said. If considered you are a significant data fiduciary, consider the DPO, DA, and DPIA request. This is a bird's eye view of the DPDPA, and I leave it now for Dr. Anirban to continue with his views on what kind of opportunities exist out of this, and subsequently we can take questions and answers. Okay. Thank you.
Sir, sir, Dr. Before Dr. Sir starts his session, I'd like to thank you. In a very short span of about 35 to 40 minutes, you have covered all aspects of the Act, starting from the application, complaints, obligations, rights and duties of the data principal, significant data fiduciary, penalties, and what are the steps in complaints. All these things you have covered, sir. Thank you so much. And kindly, after Dr. Anirban's session, please give us a brief about the FDPPI, sir.
Okay, okay, I will do that.
So now I request Dr. Anirban to, of course, to the participants. Dr. Anirban Ghosh is a forward-thinking senior manager working in BT Group. BT means British Telecom, former British Telecom, and he is overseeing data complaints for India and EMEA. EMEA means Asia, Middle East, and African countries. He is in charge of this area. He has a huge experience across different areas. He has become a key player in data complaints assurance in the group, and is an expert in data privacy, cyber security, and training matters. He's a strong supporter of FDPP. He regularly participates in the activities of the foundation. He is in charge of foundation in Kolkata, West Bengal. And he is also a respected member of Data Security Council of India. So he's closely working with FDPPA. When I requested him to inform the participants about what are the opportunities, as I told you in the beginning, this act brought in many challenges. At the same time, there are huge opportunities. I don't think there are sufficient experts to fill all the needs. So when I requested him, he readily accepted. Thank you so much, sir. Please have your session, sir. Dr. Anirban.
Thank you so much, Radhakrishna, and thank you so much, ISACA, for this opportunity to speak to all of you. I have tried to respond as much as possible on chat while Naavi sir was presenting. So Naavi sir, I have tried to respond as much as possible, and I think there's a question I was about to reply, which talks about how one can reach out to me or any one of our member. I think Radhakrishna sir is going to share the details. You can be part of the chapter, and Radhakrishna sir will be able to add you in our Knowledge Net channel. So yeah, please reach out to him, or I'm available in LinkedIn.
Yes, sir. We are sharing a Google form at the end, sir, so that the participants can share their details. We'll contact them. We'll help them out, sir.
And in FDPPI, just to add, we all believe knowledge should be free. So free flow of knowledge in data privacy field we provide as much as possible. I would share my screen. Let me know if it's visible. Let me know if you see my screen.
Yes, sir, it's visible.
Okay, perfect. So, before I get into the topic for discussions, I would like you all to imagine a scenario. So think about a national level company. Okay, I'm not talking about any multinational. Just think about any national level company. I would not like to name anyone. You can think of maybe a bank. You can think of maybe a consumer brand, a clothing brand, a supermarket, any brand you think of, and think of the brand exists only within India. So it might look like as a national organization that within India there might be not much footprint, but when you search in Google, and this is the data I have got from Google itself, that in India we have already 28 states, 8 union territories, and 400 cities in India. Now think of a bank, any bank, national, private, or maybe small finance. If they have approximately 5 branches, I'm just going roughly in number 5, which is, it might be more than that, then for a small bank, we are looking at approximately 2,000 branches. For a national level bank, when I Googled it, I found that their branches are more than 22,000 across India. So that's an organizational size which you look at, okay? And then you can multiply it, the number of customers, or in this case, the number of personal data they are dealing with. And I believe maybe most of the banks, apart from the local banks, they use digitized, they do digitized data. So the impact is going to be huge when it comes to India. And as for national level players, apart apart from IT Act, which was known as SPDI 2011, this is a big change which they are going to experience. So the market, or the organizations, need to be open for much more career opportunities or job opportunities. And this is exactly what I'm going to talk through. And I named this slide Emerging DP Roles within the Indian industries. And when anyone talks about any job in data privacy, or a company needs to hire someone for data privacy, the very first thing pops up in everyone's mind is exactly this, what you see on your screen. Again, this is the term, we heard it, we hear it on a regular basis. DPO, or data protection officer, or in some organization they call it privacy lead. Okay, we find DPO as a mandatory obligations for significant data fiduciary. They need to appoint a data protection officer who have to be based out of India. That's all we are aware of. For the non-significant one, who are the data fiduciaries, they need someone to take care of data privacy within the organization. Let's call them as privacy lead. So this is the primary role. I'm pretty sure you guys, or you all, have already experienced, or you have already seen that Indian job market is flooded with these opening. Now, the reason which I believe, and this is purely my personal view, whatever I'm going to present here, and based on my research and speaking with my contacts or connections, okay, the company's perception might be that all they need is a DPO, or all they need is a privacy lead, and they are done. They will take care of everything. But you need to understand, okay, as a DPO, I am not a Superman, or I'm a normal human being, so I have a limitation of work or activities. So what all at a national level organization, and purely national level, okay, at a small or medium scale industries, the role might be clubbed, but at a national level organization, what all emerging roles that I foresee from my side that I'm going to present to you. The first role which I see, and there was a question in the chat with a scenario that someone made data publicly available. What should be the next step? And this is exactly where the number one comes into picture. Every organization need a team who will investigate each and every data incident, or potential security incident, or data incident, and they will reach at a conclusion and will file the reporting. Now you might say that why it needs a team, or why it needs one person. Now again, if you club the number, if you think of the nationalized bank, which have got 22,000 branches across India, and if the reporting rate, or if the incident rate is at approximately 5 to 10%, then you can see the daily incident number, how much it is coming at. So this is the very first role which I oversee coming in. Okay, a DPO, for a DPO, it is not possible to invest the entire time in investigation and reporting. Based on the rules of investigation, or rules for reporting, that is yet to be published by the Data Protection Board of India, which we are still waiting. But what I believe is, not every investigation, or not every incident needs investigation. Some just needs reporting, some needs reporting along with further investigation, along with the involvement from data protection officer or the privacy lead. So the first role in Indian industry that I see is a requirement for a team who will be doing investigation and will be filing report to the supervising authority. The second one, which is again on obligation for significant data fiduciary to conduct privacy impact assessment. I would not only recommend significant data fiduciary just because it's their obligation to go on for it. This is a very good practice. I think most of us are already aware of privacy impact assessment, or conducting privacy impact assessment is a great practice to ensure we comply to privacy by design. So we might see that not only significant data fiduciary, but the data fiduciaries who are not significant, they might also start following the PIA culture, or may call it DPIA culture, or some call it SIA, or solution impact assessment culture as well. And it needs a reviewer team or a person who will be guiding the project team, connecting with them, getting the PIA drafted and documented. And finally, when it is ready and everything is done, the PIA should be raised with the data protection officer or the privacy lead, or maybe the legal team, or maybe any relevant authorities within the organization for their approval, and to document it and follow up. So the second emerging role within an organization, which I see is a PIA team, PIA reviewer, whatever you want to call it. But yes, there will be a requirement. But again, think of the size of an organization. Third one, Naavi sir touched on it. I think DSAR team, or a subject access request team. There is a there is a very bold and big discussion within this bill, which gives rights to data principals for rectification, for erasure, for stop processing, for disclosure. So this needs an organization to establish, maybe an automated solution. There are many automated solutions available in the market, but even if you add an automated solution, it needs someone to manage and manage that particular software tool, platform, whatever you want to call it, and respond within timeline. Because if you do not respond within timeline, it will be escalated to the board. So the third role within the Indian industry, which I see, is subject access request expert, subject access request analyst, team lead, manager, whatever you want to call it. And again, this team closely works with the data protection officer or privacy lead for advice and guidance where and when required. The fourth one is basically the assurance. Assurance is required. I mean, you have established a process for investigation, you have established a process for PIA, you have established a process for DSAR, you have established a process for grievance readdressal. But it's really important for the organization to demonstrate that these processes are being followed. And this is where, organization needs to demonstrate assurance. Now, the question might come, then why the DPO is getting paid? Now, again, I would go back to my previous statement. A DPO is not a Superman. Okay, it is not possible for DPO to, do an end-to-end assurance audit or assurance activity. They can do where it is required. They can pick up the assurance activity where it's required. But for an organization, for a national level organization who have got at least one branch in each cities, that's come somewhere around maybe approximately 500 to 600 branches across India, it is logically or physically not possible for a DPO to visit each and every branch throughout the year and conduct an assurance audit and get it checked. That needs a separate person to be done. It needs to be internal to me, but if the act allows and if the service provider comes with options for external, this option can go external as well. But an organization needs to ensure or demonstrate assurance to all the policies that they are bringing on. The next one I see is an internal auditor. 5. What's internal auditor? I think all of us are, within this ISACA are aware of 3 line of defense: first line, second line, third line. So the role 1, 2, 4, whatever you see there, they're either part of first line or part of second line of defense. This is the role I'm talking about, a third line of defense, where they will check the checker, audit the auditor. Okay, but this stream is currently, you might say, ISO is there, but this is purely, I'm talking about internal, where they will be checking the assurance being done properly or not. So we'll see internal auditor position, especially focusing on data privacy part. The number 6 will come training, comms, and awareness. I think I mentioned on the chat in one of the response, look, awareness and training is important. Now, we might think that, okay, we don't need number 3, DSAR, because we will not tell anyone that, you have right of DSAR. The problem will come not only in DSAR, the problem will come when you have to oblige to report an incident within a certain time period. Let's give an example. So let's consider the timeline we have received, or the current timeline that we have in India for certain guidelines is 6 hours. Now the 6 hours clock starts from when the business gets aware of it. Now the most common question which we all come across, what is the definition of business? So the definition of business is everyone within the organization, starting from uh, maybe the front desk staff to the managing director or to the chairman. Each and everyone is part of the business. And if any one of them aware of a potential incident, it is their responsibility to inform the authority within the organization or report it within the organization. If they miss doing that within the timeline, within the speculated timeline, there will be heavy penalty that the organization is going to face. This is just one example of training, comms, and awareness. And on top of that, I always speaks about human firewall. That's a different topic altogether. We might discuss it on another day. But human firewall is the first and the last line of defense for any organization. And human firewall can only be switched on with proper training and awareness and comms. So, to a national level organization, which will not have consumers or customers, but will have employees, massive number of employees. Okay, it's really important that each and every employees, along with the external customers or data principals, they get aware of and they get proper training, they get proper awareness and proper comms they receive time to time. Again, these are all will be verified, validated, or maybe consulted with the data protection officer or privacy lead. But again, I would stress, a DPO or a privacy lead is not a Superman. Okay, they cannot do end-to-end training, awareness, and comms. They can definitely be part of a training, deliver it, but arranging the training or fixing how the method of the training is going to happen, it needs a dedicated team, unless an organization want to automate it. Okay, but again, training can be automated, but awareness and comms, they need a special team. This can be consumed within the existing team of an organization, but again, this rule will come if an organization doesn't have one. So that's number 6 from my side. The 7th one, and the most important one, which you all may be hearing quite a lot these days, is data governance or data mapping. To comply with this law, the organization first need to know where is their data located, or from where the data is coming, and where all the data is going or transferred or processed. This is the part which is called data mapping, and this is overall called data governance. So you might have seen certain trainings available, certain softwares available from various national and international companies for data mapping, data governance, but it needs dedicated person within the organization. Again, this particular team or this particular people will be working very closely with the data protection officer or the privacy lead, along with various other departments like HR, finance, so and so. But yes, this is another role that we see emerging within the industry. That's number 7. Number 8, GRC. It's a well-known phrase to us, governance, risk, and compliance. Okay, organization might have this already because this is a very well-known framework within the industry. But when it comes to managing 1 to 7, if you go 1, 2, 3, 4, 5, 6, 7, whatever we discussed till now. Okay, if an organization wants, or if an organization have the capacity to add this GRC framework within the existing team, it's fine. But there is definitely, from my personal side, I would see definitely there is a requirement will come who would have to govern, manage, comply, and report. As Naavi sir said, the board need to sit and discuss. Someone needs to do the reporting to the board. Definitely, it's DPO's responsibility. DPO should be responsible. DPO should be part of the highest level of management, or reporting to the highest level of management, and they would be report periodically. But again, the DPO is not a Superman, right? He needs support. So someone should be there to govern, manage the risk, the issues, the matters, and the compliance activities that is happening within the organization. So one GRC role especially for data protection that is emerging within the industry. And number 9, consent manager, a well-known phrase, well discussed phrase after this act came into life. Consent manager, I'm not talking about consent manager from a data principle standpoint. I'm talking about consent managers within an organization. Okay. You might say, is it a full-time job? Can't it be automated? Yes, it can be automated. It can be automated through a system, but there is someone required who will manage all these consents or all these systems and will closely monitor, change, and update accordingly. Okay, again, they will be closely working with DPO or privacy lead, because the complaint for any violation of consent will come to the DPO or the privacy lead, which requires support from this particular dedicated team. If you're thinking why we need a person to take care of consent, just imagine the product sold by any national level bank and how many consent they will be dealing from now onwards. Okay, based on their customer base. I mean, just as an example, if someone have one savings account, one public provident fund account, 4 to 5 mutual fund with a bank, okay, that individual average looking at 6 consents. Okay, so the bank have to manage 6 consent for that one individual. You can multiply it with the number of customer base, which you can Google and find out. So it requires maybe more than one, but as of now, let's keep it one consent manager each organization to take care and manage all the consent, look into the updates coming from government, and ensure that the existing software system comply to the requirement. Well, I can speak all day, but Mr. Rao gave me a very strict timeline, so I'm added only 10, and the number 10 what I have added, it's called a CDO. Okay, the full form of CDO is Chief Data Officer. This is a very new, fairly new concept, maybe 4 to 5 years old, coming into system, which India may not see right now, but as Indian law, this new law will be more and more mature, you will see this coming into picture. Chief Data Officer. CDO is a complete separate function. Okay, it needs a whole session to talk about CDO, but you can definitely search. You can see recently we have seen, part of the PIPL China has come up with this CDO concept. So, I'm not saying we'll be inspired, but CDO is required. CDO, Chief Data Officer, is completely different function than a data protection officer within an organization. But yes, maybe not now, down the line, 12 months or within the new era of digital India, we will see this role will be emerging for sure in going forward. So that's pretty much from my side. I can take any questions, but I would hand it over to Mr. Radhakrishna.
Thank you so much, Dr. Anirban. So you have brilliantly covered all the roles to be played by human beings under DPDPA. There are much more opportunities available under this act. Thank you for introducing all these opportunities to our members. And sir, we will take up questions at the end. Before the questions, I would request Naavi sir to, because a number of participants are asking about the membership in FDPPA certifications. So I would like to request Naavi sir, who is the chairman of FDPPA, to introduce FDPPA in detail to all our participants. Sir.
Yeah, thank you, Radha. See, FDPPI stands for Foundation of Data Protection Professionals in India. People are asking whether we will make it Bharat. That we'll see for some time in future. Okay, but basically it is an organization of the professionals, by the professionals and for the industry, in the sense that this is not a organization which is promoted by government or even NASCOM or even a big company. It is actually an organization of the data protection professionals, all of whom have got lots of experience. We have about 250 members as of now in different categories. We also have supporting members who actually work with FDPPI to deliver services on a revenue sharing basis. And that they are actually the backbone of this particular organization. And we started in 2018, and somewhere in 2019, we started looking at certification programs because we wanted to create professionals with specific knowledge of Indian data protection requirement. So we felt that no other certification is providing that kind of a focus. We have started giving it. Since we started providing certification programs before an act came into India, at that time, the act which applied to data protection was Information Technology Act. Information Technology Act itself was a data protection law until 11th of August. Okay, now a new law has come, and that is, along with the ITA 2000 leftover, becomes the data protection law. So we started our activity before this new specific data protection law came, but in every one of our certification programs, we have been following a policy that the next major change of the act will be covered freely by a bridging session. And that we have continued to do even before this act came. We had started a program in July 2023, and we had just in the completing stage when this act came, we gave them a bridging session, and this will continue because this law is going to be dynamic, and until another 2 or 3 years there will be a lot of changes because of the regulations or notifications which will be coming through. So once any person gets into our certification program, we try to ensure that he is continuously being upgraded. Through this bridging session, we have got weekly knowledge sessions, and maybe even our Telegram group itself is an education kind of a platform. So through various means, we are trying to ensure that professionals remain informed. Okay, that is one part of development of skill sets for the professionals. Then on the other end, we are trying to provide the audit or consultancy services to corporates, but those services will be rendered by our supporting members. So FDPPI will provide that kind of a service. Then we also have a framework which we earlier called as Personal Data Protection Standard of India, PDPSI, and now we are going to call it as Data Governance and Protection Standard of India, because we earlier also we used to call that as a unified framework for GDPR and Indian law and CCPA kind of a thing. The unification was over different laws so that you will have one compliance framework for multiple data protection laws. Now it has become necessary to combine the provisions, so some part of ITA 2000 into DPDPA and the data governance standard, which has been released by the Bureau of Indian Standards recently as a draft. And ours is the first program which takes into account this new law. And what Anirban was talking of CDO, we are creating that CDO right now because our next training on this module on audit will be including this data governance framework. So we have the skill sets from professionals through certification programs. And that certification program itself has got 3 modules: Module I on Indian law, Module G on global law, so GDPR and other things are covered there, and Module A on audit. All the 3 together, we call it as CDPO-DA. That is certified DPO, and DA is data auditor, because we find that data auditor is also a coveted individual activity, entrepreneurial activity, which will develop. Many of the senior professionals who are good in auditing may not work as DPOs in an organization, but they may actually take up data audit work, because the significant data fiduciaries need to appoint DAs, data auditors, on a continuous basis to conduct, say, periodical audit, and of course once in a year at least have a certification done. Okay, and these people who are trained in all the 3 modules of Module I, A, and I, G, and A, or the CDPO, DA kind of people, are permitted to actually take up audits which are certifiable. Say our audit framework is a certifiable audit. It can also be used for implementation within the company, and it is also an assessment framework, because we calculate data trust score at the end of the audit, and that is one of the parameters for our auditors to qualify their particular data audit. So one, they will audit for certification purpose based on what we call as an adopted implementation specifications. We calculate DTS on the basis of model implementation specifications. This is a unique process in itself, which you should actually perhaps discuss on some other occasion, or better go through our CDPO DA training program. There is no other program which is comparable to what we are doing presently. First of all, combining the ITA 2000 with this was itself an innovation, and now this in the audit module, combining the BIS data governance into this is another innovative thing. So and in future others may come up, okay, but right now on this point, and no global organization, no Indian organization has a content format which is what we are giving. We hope that is required. Now, subsequently, we are also trying to work on a platform which can exchange the services. We want our accredited people to go into what we call as a register. We have opened a register called Indian National Register of Data Protection Professionals. So all our trainees automatically get entry there, and others who are not undergoing training with us can also register upon payment of a small fee. So you can create your own recognition in the industry. So you train yourself, you gain your recognition, and then use our framework. It's like an end-to-end service. And we also have for lawyers a platform called Data Disputes and Mediation Center. We are trying to create such a platform where experienced data protection law experts can join and then offer a mediation service or dispute resolution service, which can perhaps be given to multiple companies. Even if DPO service cannot be shared, we don't know whether shared DPO service will be given. Shared grievance redressal services can be given by this platform, and the experts can join there, and we have to develop a mechanism by which we attract the other companies to make use of these services. So through these multiple services, we have tried to create a whole chain of things for the professionals to grow and also use their services. Hopefully, over a period of time, it will take root. Our members, basically, we have one important category of members called supporting members. Supporting members are persons who actually continue to donate their efforts to the organization by executing joint projects and sharing the revenue of the joint project with FDPPI. So it is an effort donation concept. There are also corporate members who receive our services from our members at a concessional right? So corporate members are there, supporting members are there, and individual members. At present, we are accepting what we call as a basic member category, who are entitled to all the services of the organization. We have a limitation as far as the voting members are concerned, because ours is a private limited company. 200 is the maximum limit. So we have stopped taking what we earlier used to call as foundation members. So we have frozen the number of foundation members at a particular stage, but all the services are available to the non-voting members, who are called the basic members. So that is one which is open. And most of our training programs, for example, say DPODA, which we are charging 45,000 rupees now, it includes 6,000 rupees of membership fee and 3,000 rupees of this registered INR, that is Indian National Registration fee. So we are, and also GST. So our highest training program as of today is around 30,000 rupees, which is far, far less. It is half of what an international organization which talks about GDPR is going to charge. They don't teach the Indian law. We are teaching Indian law. And in addition, we are teaching GDPR law, Singapore law, CCPA law. Our module G consists of minimum 6 or 7 data protection laws, GDPR in detail, CCPA and CPRA, and then Singapore law, then HIPAA. So our content is much, much wider. But we are like a startup. We may not look very organized like an international organization, but only people who have gone through these training programs can perhaps vouch for whether the programs were useful or not, even in comparison with others. It is open to any of you to do that evaluative exercise, discuss with people who have undergone a CIPP program or a DSCI program, and then also our program. There are many such people, and you can evaluate the content value, because our content has been decided based on our professional experience. So it is not something which is pushed down by an organization. We have decided to bring it. And tomorrow, when the data auditors are there, ours will be perhaps the training ground for data auditors. We are going to also have a very special service shortly, which is that now all the companies want to recruit DPOs, and you may not have time to go through a DPO course, which takes about 15 days or minimum 1 month or something like that, because our next module A will start only in October end. So it will take 1 month. So we have also been working with one of the placement agencies to ensure that the placement requests which they receive will be supported by a mentor session. So if you are having an interview for a DPO next week, maybe you can have a mentoring session with us, and we will try to give you a crash course on the Indian DPO, Indian data protection law, so that you can perhaps do better in the interview. So these are some of the thoughts which are oriented towards what is required by the community. This is not guided by either a reason to make more money or something like that, but it is a felt need of the community, which all of us have perhaps felt at one point of time or the other. So this is about FDPPI. We have got a board of directors with 3 directors. I am the founder, director, and chairperson. Nagendra Javagal is the other founder director. Ramesh Venkatraman is another director. We have got chapters at multiple places. Hyderabad is one chapter where Radhakrishna Kalangi is the chapter president. Dr. Anirban is the chapter president in Calcutta. We have chapters in Bangalore, Pune, Bombay, Madras, and even in Bhubaneswar, one person we have identified. Delhi, we have identified somebody who has to still start working. And all these people together form what we call as a governance committee. And that governance committee will work with the board to conduct more such activities. In fact, every year we conduct a program called IDPS, that is Indian Data Protection Summit. We are conducting this year's IDPS 2023 on November 24th and 25th. I hope dates are correct. Either 23, 24 or 24, 25 is Friday and Saturday. And that will
24, 25, sir. 24, 25.
24, 25. Okay. That will be happening in Bangalore as a physical event. Last 3 of our activities, IDPS was actually virtual event. So this time we are having a physical event in association with or in partnership with Manipal Law School. The Manipal group is collaborating with us in all educational programs of theirs because we are supporting them in their LLM program and others. And we are using their infrastructure for conducting this physical program. So that is one of the you can say flagship events we have. Other than that, we have been conducting events on various other occasions like the Privacy Day. We have conducted a Digital Society Day, October 17th. I used to regularly celebrate it as a Digital Society Day because that was the day when Information Technology Act was notified. So on those specific occasions or even otherwise, we try to conduct programs, but we are looking at support from other organizations. We have been conducting programs with ISACA at many places. We have been conducting with Madras Management Association. We feel that we are like a federation of data protection professionals. We want to work with all people. Sabka Saath is our kind of an approach. And wherever others come forward to help us to set up such programs, we are willing to provide our people and say the knowledge sharing, because otherwise we are not having the resources to have too many offline activities. So I mean on physical events, but we are going to have a number of online events whenever it is possible. In fact, I have now committed to taking data protection to IIM Udaipur this week. Next week, I'm starting a course there, which is on data protection, but combining with the MBA requirements. So that is the first program of data governance and data protection and creating the CDOs from the college premises. So say I work closely with Nalsar. Nalsar already has done 2 or 3 programs on PG diploma in cyber law. They have been doing earlier. Now on data protection law, we have discussed Indian data protection law and international data protection law with Nalsar. Now we are taking this data protection law to the IIMs. So in a way, we are trying to ensure that the whole community in India is made aware of these activities. Okay, so that is roughly what is FDPPI. We are still only 4 years old. So in the startup community, 10 years is the limit. So I think we have still got a lot of time to actually grow bigger and bigger. But I would invite every one of you to actually join and make this your say organization. Okay, I am there as a promoter. Every organization needs a promoter, so it cannot just have it. So I am there, but I would like today's 300 members to become 10,000 members. Okay, because there are so many people associated with data protection. They should all come together, and we should grow to such an extent that we become a big force in the country when it comes to data protection. Right now, of course, we are reasonably well, say, noted even by the government. But beyond that, we need to really become a force to reckon with, for which more people have to join together. If you feel you can join together as a basic member, you are welcome. If you want to join together in any of our training programs, we welcome you. And in October, I'm starting the next module A, and now module I and module G is available on recorded mode. People who join now, they can go through this module I and G and then join for the program on module A by October. So that end of October, we will be having one new batch of the people who are trained in the current knowledge base. Okay.
Sir, I think there is one question in the chat, sir, which asks that what is this basic member is all about. So if you just
basic membership provides access to all our services. But as of now, we have tried to provide most of our services to people without any restriction, though there is a frequent demand that many of our free activities need to be actually restricted to members. And basic members will also get discounts when we handle more of physical events. Right now, when we have a virtual event, we don't want to actually restrict too many things. So the weekly knowledge sessions are open to people who are not basic members also. But we would like more of basic members to come in, and we soon may create premium content in FDPPI, which will be made available only to basic members. Physical events, when we conduct, the delegate fee will definitely be different for these basic members. In fact, every one of our members have got some kind of a cashback in the training programs, and I am confident that every one of our members are now running on a zero membership fee basis. They would have got some kind of a benefit discount in the next training program and other things. But otherwise, basic members are the persons who are going to be the people who support this organization in various activities which we are doing, and they will get corresponding benefits for the in terms of financial terms. Okay. Yeah.
Thank you,
Any
sir.
other questions?
Okay.
Yeah, we will take up, sir, questions. Thank you so much, sir, Naavi, sir. So amazing. I think members got sufficient information about FDPPA, and frankly, we the members we know well about Naavi, sir, for quite some time. We treat him as God in the field of data protection laws. I think you got very good information about FDPPA. We are there to support you in all aspects, in knowledge sharing, trainings, and whatever needs you have in data protection, we are there. We will share, in a few minutes time, we'll share 2 Google forms. Please fill for ISACA members. One form will be shared so that they will get the CP hours. For others, please share your data and email address so that we will connect with you and give all the information required by you. Whatever way we can support you in data protection, we will do that. And this forms will be shared by our Mr. Vijayashankar Kottapalli, who is member of our core group, FDPPA Hyderabad. And I request Vijay to take up the Q&A also.
There is one question from AK. You can ask him to speak out.
I can unmute.
Yeah. AK, please unmute yourself and do you, please. Thank you.
Sir, I will allow you to unmute yourself. Please unmute.
Yeah. Hi, good morning. Good evening. Sorry. Hello.
Yeah, tell me. Yeah.
I have 2 questions, Naavi sir, for you. First of all, when the draft was submitted in the Parliament for debate, there was the last part of the bill stated that this act would replace the 43A, section 43A of the IT Act. So I just went through the act, but I couldn't, rather was not any direct reference, couldn't find it. So can you guide on me that whether
it is there? It is there in the last chapter, a miscellaneous chapter.
Okay.
You can take the exact thing that is, I think somewhere total 44 sections are there. This should be 38 or something like that. Okay. Vijay is trying to see that if necessary. There is a website called DPDPA.in. Okay. You please open that, you will get the details. And the copy of IDA 2000, which is available on my site, naavi.org, already has this modification incorporated there. So 43 capital A stands deleted. Okay.
Yeah. So my second question to you is that as you said that if the DPD Data Protection Board will be the first authority where the data principal can approach. Okay.
You can say grievance redressal is the first stage, which is maintained by the data fiduciary himself.
Yeah. Then the approaches the DPD, the board, else it goes to TDSAT, or else they can
First
go
we'll
to.
go to DPB. Okay,
Yeah,
DPB will consider it, and then you can take the appeal to the TDSAT.
Yeah, and even if the appeal, if it's not I mean, either party is not satisfied, they can go to the Supreme Court.
Correct.
Now, in that case, since the data fiduciary has an obligation to take a consent and to delete the data whenever asked by the data principal, that being in one of the things. So can, considering all this things, can the data principal then also opt for an consumer protection, under consumer protection, that they can go to a consumer forum seeking damages?
I feel that once a law like this is available, and you are, even the cause of action is under this law, then you have to take only this mode. Okay. If the cause of action is deficiency in service, and it doesn't come under data protection law, then you can go to the other forum. The same thing used to happen in the ITA scenario also.
Exactly. That's why I asked you. That's why I asked you. No, because my point of asking is because here nowhere the High Court is involved. You directly go to the Supreme Court as an apex authority.
Not only that, if you want personal remedy, then you have to think of either the consumer court or the ITA 2000 adjudicator, because this act is not going to give personal compensation to the data principal. So you can, like in the criminal case, say you may lodge a criminal complaint with the police, but you continue to have a civil proceedings in a civil court for recovery of your damages. In ITA 2000, like adjudication. So both will go simultaneously because the end results are different. Likewise here, you lodge a complaint with the DPB, but don't expect any compensation to be given to the data principal. If that is required, you can go to the either the consumer court if it is deficiency of service, or you better go to the ITA 2000 adjudicator. Okay. So appropriate forum you have to select. There have been instances where consumer courts have given verdicts when it was not under their jurisdiction. It actually should have been taken under the adjudicator. But sometimes courts do make mistake because the other lawyer is not questioning the jurisdiction. If the other lawyer questions the jurisdiction, you cannot proceed in the consumer court. Evidences cannot be appreciated in the consumer court. It is a different forum for a different purpose. Just because it is easy to approach consumer court, people go there. And remember, the and also cost may be lower. Okay, your adjudication in ITA 2000 costs about 2.5% court fee. I think consumer court, it is just 5,000 rupees or something of that. DPP, of course, for lodging a complaint, you don't have to incur any cost. So you have to decide which is the correct forum. I feel the correct forum will be DPP for lodging the complaint. And at the time of decision in the IT adjudicator, if the DPP has already given some verdict saying that data fiduciary is wrong, you can try to quote that in the adjudicator's this thing and say that this was the problem which has been held by the DPP. Now I have suffered this particular loss, because you have to justify the compensation in adjudication. You have to say whether you have suffered 5,000 rupees loss or 5 lakh rupees loss. That you can do in the adjudication table, and you may get the compensation.
Sir, just a corollary to my question, to what you said, and my last question. In case, as you said, first he goes to the grievance officer, then to the data protection board, and then to the TDSAT. So now after TDSAT, instead of going to a Supreme Court, what if someone goes and files a writ under 226 in the High Court?
You should reject it. Say, no, you are a liar.
Yeah.
Okay, now, even today, people go directly to Supreme Court before exhausting their remedy with many trial courts, is it not? So Supreme Court has become actually the first court of trial rather than the last court of disposal. Okay. And constitutionally, if you want to invoke 226 or something like that, you are invoking constitutional right. Okay. Now, this is actually the procedure with the constitution has given to you, and you are anyway having access up to the Supreme Court. The whole process here in DPB may not take more than 3-4 months, and you have an access there. So I feel there may not be any need to go to the High Court. I do understand that practically, if you are an advocate working in Hyderabad, it is easy for you to approach the Hyderabad High Court than going to the Supreme Court. But I think in this particular case, the High Court has been actually bypassed to some extent. As I told you, in ITA 2000, High Court comes in here. TDSAT, all appeals to which go to TDSAT in telecom regulatory things also go directly to Supreme Court. I don't think there is a High Court option there. Okay.
Thanks a lot. Thanks a lot. Thanks a lot.
Yeah.
Okay, I think, yeah, I also want to announce the curtain raiser program for the ISACA certifications. So we have CISA, CISM and series classes coming up. So members of FDPPI can be part of it. So I've shared the contact details of mine. You can just WhatsApp me with your interest of certification. Then we'll give you more details. Thank you.
Thank you.
Well, thank you, Praveen, for sharing the details. Members may please take this advantage of review classes. Probably it's going to be more challenging for other this thing, because the kind of qualifications the nodal agency like Satin is asking for CISA and all, CISSP, so and so to be part of your qualification to get empanel. So that is one. And thank you very much, sir, for the kind of, because I was actually trying to pitch in for picking up the questions, and Anirban Ghosh is an example what your community is doing, because he was responding then and there for every question in detail, much detail. So that shows the kind of give back what you're giving through FDPPI. That is an example. Otherwise, members, if you have any questions, kindly please unmute yourself and you can speak out. Or else you can even mention in the chat area. Yeah, for form for non-ISACA members, I already shared it, but let me just share it again. One I've already shared with the for the sake of ISACA members to claim your CPE, and I've just shared another link for members who are interested for the details about FDPPA, and also non-ISACA members can claim their participation certificate by providing the details. So any other questions? If anyone has any questions with regard to something in the chat. I'm sorry. Yeah. 1 second. 1 second. Yeah. I've 1 second. Yeah, I've mistaken.
Yeah. This link is going to YouTube. Vijay, please share the Google form. Yes.
My mistake. Just give me a second. I'll do it right away.
Request participants to share their email ID so that we'll connect with you. Please fill the form without fail.
Just a second, sir. I'll be sharing this Google form. Yeah. Kindly check and confirm if it is working. Anyone, please. Yeah, thank you. So that's a link for those non-ISACA members to claim CPE participation certificate, and also to get the details about FDPPI. And ISACA members have already shared the link for providing the details to claim your CPE credit. So unless we have any doubts, though we have another 5 minutes, unless you have any doubts, probably we can conclude. And just to add what Praveen has said, this is the second session on this subject simultaneously. And obviously, I felt like this requires more and more, at least we have time till the date is notified, but it's the time to gear up and get into this act. Interestingly, Naavi sir, I've come across doctors, advocates, coming into this, and they have in fact showing interest in getting into this particular act. So that way, we'll see good number of other professionals also joining this, which is encouraging. At the same time, opportunities also, the way Anirban has mentioned, I still feel it's insufficient in terms of even if it comes at the full force. I don't know how it is going to. I mean, I can't even dare to imagine the kind of the gap what this compliances will be.
So just wanted to add. I mean, I look for openings within privacy industry, and part of my practice is put it in our FDPPI community, okay, for everyone's. So I have seen massive hike in DPO roles. I have seen a public sector bank, which is, I would not name it in this call, but they're the biggest bank in the public sector within India, with the biggest international presence. And they have come up with, I think, 3 openings to my knowledge. And all 3 openings are related to DPOs. So somewhere, and my designation used to be DPO a few months back, but we are not calling ourselves DPOs where it is not required by the law, because you might be part of a lot of audit, a lot of unnecessary investigation, and attract a lot of supervisory authority. So where it's not required a DPO legally to be having, we don't call ourselves DPO anymore, and that's where we call privacy leads, compliance leads, all these stuffs. So when I saw these jobs coming in, I can understand what is the perception of the industry. The perception of the industry is, let's hire a DPO and our job is done. We'll do everything. So what I tried to establish today is DPO is not a superhero. We don't have multiple hands. We are not Iron Man, okay, who can do multitasking together. We are human beings. And a proper compliance to this act requires a full-fledged team and support from all operations unit and all other unit. So that's exactly what I try to establish, followed by what Naavi sir explained the act, so people can relate. If I'm talking about DSAR expert, where it is relating back. If I'm talking about reporting an investigation, where it is relating back. And yes, I think it will take some time for the industry, and I think it's a great forum to address all of you. I'll share the slide with Radhakrishna sir. He can mail it to all of you, so that you can, if required in your board meetings, you can cover this and just let people know, look, this is what we need. So industry can be ready with no surprise.
Thank you very much for that.
To just add to what Dr. Anirban has just said, with this groundbreaking legislation having been passed, I think this is still too early a stage, and especially banks and fintech organizations are actually validating the provisions of this act. There are points of divergences as well with regard to jurisdictional conflicts, financial consequences, etc. I think a great deal of study is being undertaken at this point, and then I think the time will only tell how successful this act would be.
Yeah, I mean, I totally agree. Look, I'm really, blessed by getting in under umbrella of Naavi sir, I think for last 2.5 to 3 years. And that's a great achievement for me, to be honest. And secondly, I work with multiple jurisdictions, so I come across lots of laws and compliance. But I think, yes, the Indian industries, the purely national level industries, they are not blessed with all this. Though Naavi sir is there to help and guide, and we do not charge any consultation, to be honest. As I mentioned, we keep knowledge free flowed. So yeah, welcome whoever want to join us in FDPPI and be part of the community. You don't always have to be a member to join our community. The community is free for everyone.
So a big thanks to Naavi sir for enlightening us with the provisions in their entirety and clarifying on certain aspects of the act. A big thanks to Naavi sir.
Thank you, sir.
Thank you.
So I think we can close it now. I request Mr. Vijay Srinivas to propose vote of thanks.
Yeah. Thank you, Radhakrishna sir, and thank you very much. Before I thank both the speakers, I also thank Praveen for collaborating and to see that Hyderabad FDPPA reaches a larger kind of members, to give awareness about this organization to the ISACA members, and also with regard to the subject. Special thanks to Naavi sir. I mean, more ground to earth, and I haven't come across any personality who relentlessly shares the knowledge day in, day out, even in the nights, whenever we come across some chat and all the kind of feedback he gives, he corrects a couple of provisions, I mean, interpretation. All that's really great of you, sir. And thank you very much for coming over here and addressing our ISACA members on the topic of DPDPA. And as well, the kind of I mean, the way professional opportunities, most of the time we think about DPO or a couple of specified roles. You have explained in detail the other supporting roles which might be possible, and the way the opportunities it will create as a team when it comes to a special thanks to both of you for addressing ISACA members and also FDPPA members. And we hope to have more such sessions from you. Probably once the dates are notified, we may even plan for a workshop kind of thing. There's so much of skill set in terms of drafting those consent request forms and all that. We'll hope to have more such sessions from you.
Thank you.
Thank you so much.
And,
Thank you, sir. Thank you, Naavi sir, Dr. Anirban, Vijayashankar, Praveen, and everybody. So, so we are closing it, sir. Thank you. Thank you so much, sir.
Thank you all the participants. Thank you very much.
Thank you all.